Swayam Prabha. Digital India. Educated India.
Hello friends, in earlier session we had the discussion over the topic of constitutionality of delegated legislation or the permissible limits of delegated legislation, wherein we discussed the constitutionality or permissible limits of delegated legislation in United Kingdom, in United States of America and in India. In the present session, I would like to discuss the topic procedural and parliamentary control on delegated legislation. Friends, it is important to know that there is a difference or a point of difference lies in these two, the constitutionality of delegated legislation and the control over delegated legislation. When we talk about the constitutionality or permissible limits of delegated legislation, we refer to the control at the first stage of delegated legislation, where the parliament or the legislature is delegating its legislative powers to the executive. And when we talk about the control over delegated legislation or the control mechanism of delegated legislation, we refer to the control at the second stage of delegated legislation, where the delegate in the exercise of delegated powers makes the delegated legislation. So, the procedural and parliamentary control, it is the control at the second stage of delegated legislation, where the delegate is exercising the delegated power and making the delegated legislation in the form of rules, regulations, bylaws, notifications, orders, etc. Procedural control and parliamentary control, both are clubbed in one topic because of the fact that both belongs to the procedure of making the delegated legislation. Under the topic of procedural and parliamentary control, we can divide the discussion into two subtopics, the procedural control and then the parliamentary control. When we talk about the procedural control on the delegated legislation, it has 4 stages of the control. As the delegated legislation is made or it is passed in its making through 4 stages. First is the drafting, second is the pre-publication or the prenatal publication of delegated legislation, then number 3 the consultation, and 4 the post-publication or the publication of delegated legislation after it is finally made. The drafting is the very first stage of delegated legislation. At the stage of drafting, how the making of delegated legislation can be controlled? It has been advised by, suggested by the Donogh-Moore Committee or the Committee on Ministers' Powers. At the stage of drafting, it is the suggestion of Donogh-Moore Committee that the experts should make the delegated legislation or the expert draftsmen having legal skills and knowledge should be involved in making of delegated legislation. Why the experts? And the experts, especially the experts who have the legal knowledge and legal skill, should be involved in the making of delegated legislation. It has one reason or justification, that if the experts are involved in making of delegated legislation, that delegated legislation may not be vague, that delegated legislation may not be full of the ambiguity, and therefore it will be easy for the public or for the affected groups or for the persons for whom the delegated legislation is going to be made, that they can easily understand the provisions of delegated legislation. It is also important for delegated legislation, for the drafting of delegated legislation particularly, that the expert draftsmen who have the legal knowledge and legal skill should be involved, because of the fact that if there is any legal lacuna or there is any legal infirmity in the delegated legislation, it becomes the subject of litigation, and then all the energy, all the time which has been used in or which has been expensed in the making of delegated legislation, that would go in vain. And therefore, it is important that for the drafting, the expert draftsman should be involved, or the draftsman who have the special knowledge of law, who have the special skill of law, they should be involved in the making of delegated legislation. Another important suggestion which was put forward by the Donogmore committee is that in the making of delegated legislation, there shall be the use of simple, clear and unambiguous language. It is the important suggestion being given by the Donogmore committee that the delegated legislation must be in such a language which can easily be understood by those for whom that delegated legislation is made, and therefore very simple language should be used in the making of delegated legislation. Clear words should be adopted in the making of delegated legislation, and the language being adopted by the draftsman in making the delegated legislation should not be ambiguous. Unambiguous phraseology, unambiguous language should be used by the draftsman. Then the second stage of the making of delegated legislation is pre-publication. If we see how we can control the making of delegated legislation at this stage of pre-publication, we can refer to the situation of America and Britain first. In America, Section 4 of Administrative Procedure Act 1946 provides for the requirement of pre-publication. This Section 4 of Administrative Procedure Act requires the proposed rules be published in Federal Register, with the exception that authority may not publish in case of impracticality, if it is unnecessary and if it is contrary to public interest. So, the Section 4 requires the pre-publication of proposed rules or proposed delegated legislation only with only 3 exceptions. The authority may not publish the delegated legislation if it is unnecessary to publish, if it is contrary to the public interest to publish the delegated legislation, and if there is any impracticality in publishing the proposed rules or proposed delegated legislation. Only in these situations the authority may not publish, otherwise the mandatory requirement has been made by Section 4 of the Administrative Procedure Act for the pre-publication in US. In UK, the Rules Publication Act 1893 was there, which contained the provisions for pre-publication, but this Rules Publication Act 1893 was repealed by, after seeing the situation in USA, if we try to find out the status of this requirement of the control the pre-publication in UK or in Britain. In Britain, the Rules Publication Act 1893 was there, which contained the provisions for pre-publication, but this Rules Publication Act 1893 was repealed by the Statutory Instrument Act 1946. Now, after the enactment of 1946 Statutory Instrument Act, there is no provision in England and Britain for the requirement of pre-publication of delegated legislation. Only for the post-publication the requirement has been made in the Statutory Instrument Act, but for pre-publication there is no provision making the requirement of pre-publication of delegated legislation. And therefore, in Britain the dependency is on the Parent Act. Whether the Parent Act provides for any such requirement of pre-publication of delegated legislation or not, it depends for the procedure of the administrative authority to follow in making the delegated legislation. If we talk about the Indian situation regarding the requirement of pre-publication of delegated legislation, we do not have any such general law to regulate the area of delegated legislation as it is there in America in the form of Administrative Procedure Act and in Britain in the form of Statutory Instrument Act. We do not have any such general law to regulate the procedure of delegated legislation, and therefore, we always dependent of the parent act, whether the legislature at the time of enacting the parent act, at the time of conferring the powers, at the time of delegating the powers to the administrative authorities for making delegated legislation, if the parent act provides for any such requirement of pre-publication, then it becomes obligation over the concerned authority to pre-publish the draft rules or proposed delegated legislation. Otherwise, there is no such general requirement for the pre-publication of the proposed rules or delegated legislation in India, except one requirement or one provision under the General Clauses Act 1897. In General Clauses Act 1897, section 23 makes the mandatory requirement for the pre-publication of the proposed rules, regulations and bylaws. But if we see the phraseology adopted by the legislature in enacting section 23 of General Clauses Act, it seems that this requirement or this provision under section 23 of General Clauses Act, it is applicable only when there had been the requirement for pre-publication in the parent act itself. This section 23 of General Clauses Act provides for the requirement and mode of publication of rules or bylaws if the power to make rules or bylaws is given subject to the condition that the delegated legislation should be made only after satisfying this condition. It means that section 23 applies only when in the parent act this condition has been put that the authority will make the delegated legislation or the authority will finalize the delegated legislation only after fulfilling the requirement of pre-publication. Otherwise, section 23 of General Clauses Act does not apply. It also provides for the mode of pre-publication if such a requirement of pre-publication has already been made in the parent act, that such publication shall be made in the official gazette. Then the next stage of making of delegated legislation is the consultation. The process of consultation of delegated legislation is the most significant part of the process of delegated legislation or the technique of delegated legislation, because of the fact that this is the process or this is the stage of delegated legislation which makes the delegated legislation more relevant. The reasons for the growth of and development of delegated legislation, if we see, which we have already discussed in earlier lecture, if we try to find out the reasons for the growth and development of delegated legislation, then one of those reasons is the public participation in the making of law. When the general legislature enacts the law, there cannot be direct participation of the affected groups, direct participation of interested persons, direct participation of those for whom the legislation is made, and therefore the technique of delegated legislation can be the technique of priority, because it ensures the public participation in the making of delegated legislation, and hence it makes the delegated legislation more democratic. It democratizes the process of making of delegated legislation, and therefore the process of consultation with the affected groups, the process of consultation with the general public, the process of consultation with the affective interest, affective persons, it is most significant part or procedure of making of delegated legislation. The consultation can be made in various ways, like the consultation with a body named in the parent act, or it is also called as official consultation. We can refer to the Banking Companies Act to see the example of such kind of consultation with the named body or official consultation. In the Banking Companies Act, there is the requirement that there shall be the consultation with the Reserve Bank of India. So, this is the consultation with the named body. in the Parent Act itself. The second kind of consultation is the consultation with administrative votes. There can be the requirement in the Parent Act itself that before making the delegated legislation, the concerned administrative authority is to consult with a certain administrative board. Then the consultation with board created by the statute. This is also one kind of consultation wherein the administrative authority which is engaged in the making of delegated legislation is required to consult with the board created by the statute itself. We can refer to section 4 of T Act. Under section 4 of T Act 1953, there is the requirement for making the consultation of T votes, and these T votes have been created by the statute itself. Then the government is to make the rules after the consultation with the T votes only. Then the next category or next kind or type of consultation may be the consultation with the affected groups. This is the direct participation of those for whom the delegated legislation is going to be made, and therefore it is sad that the process of making of delegated legislation is more democratic than general legislative process. There may be one more kind of consultation, that is the preparation of rules by the affected groups. Under the Mines Act 1952, there is a provision that the owners of the mines, they can enact the rules, they can make the rules for the security of mines. So it is also one kind of consultation wherein the rules are being prepared by the affected groups. The example may be the Mines Act. The process of consultation, if we see the requirement in the Britain or in England, it seems that there is no mandatory requirement in Britain for the consultation. If the Parent Act provides for any such requirement of consultation, then the administrative authority is obliged to make the consultation with the affected groups, to make the consultation with the concerned persons. Otherwise, there is no provision to make the consultation mandatory for the administrative authorities engaged in making of delegated legislation. If we see the status of the requirement of consultation in America, in USA, again section 4 of Administrative Procedure Act 1946 provides for the consultation by way of submitting data, views and arguments. By way of submitting the data, views and arguments, there may be the participation in the making of delegated legislation. Public participation is ensured by this way in America. Opportunity to interested persons to participate in the administrative rule making has been given by section 4 of Administrative Procedure Act in US. Then the stage of post publication comes. This is the stage when the administrative authority has finalized the rules, has finalized the delegated legislation. Then the requirement of post publication becomes most relevant part of the procedure of making of delegated legislation, because we know that there is the legal concept or legal principle that ignorance of law is no excuse. When the ignorance of law is no excuse and a person may be punished even after he does not know about the law, then it becomes the mandatory obligation over the state, it becomes the mandatory obligation or the duty over the administrative authority which has made the delegated legislation or which is going to implement or enforce this delegated legislation, that it should make the delegated legislation first public, and only then after making it public, after publishing it, it should apply this delegated legislation. All the means for making the delegated legislation public, all the means to make the persons for whom that delegated legislation is made capable of knowing about the delegated legislation, about the new rules or regulations or bylaws, it is the duty of the authority to make those persons capable of knowing these things and it can be made only by way of publishing the delegated legislation in a proper and effective method. So, the post publication becomes the mandatory requirement irrespective of any law, irrespective of any provision in the Parent Act, irrespective of any mandatory or obligatory requirement being made by the Parent Act or any general law. The post publication is considered to be mandatory requirement in the area of making of delegated legislation. If we see the situation in Britain, Section 3 of Statutory Instrument Act 1946 provides for the mandatory requirement of post publication, and it is provided by Section 3 of Statutory Instrument Act that a delegated legislation, a rule, a statutory instrument cannot be made effective, cannot be enforced unless it is published. Then in USA, Section 5(1) of Federal Register Act 1935 and Section 4C of Administrative Procedure Act provides for such mandatory requirement of post publication of delegated legislation. Therefore, in Britain and US are both the places, the post publication is made mandatory by way of two different legislations at these two different places. In India, as we know, as I have already told you, that there is no general law to regulate the procedure of making of delegated legislation. Therefore, we are always dependent of the provision of Parent Act, whether it makes any such requirement of post publication or not. In India, there is no general law, but if we see the judicial approach regarding the requirement of pre-publication in the process of making of delegated legislation, then it seems that the Indian judiciary has established that the post publication, the requirement of post publication is the mandatory requirement, and no law, no delegated legislation can be enforced, can be implemented without its publication or unless it is published properly. We can refer to the case decided by the Supreme Court in 1951, just after the commencement of Indian Constitution, just after the establishment of the Indian Supreme Court. This case was decided. The name of the case is Harla versus State of Rajasthan. In the case of Harla versus State of Rajasthan, there was the matter of Jaipur Opium Act, which was enacted by the legislature of Jaipur, but it was never published. One person, Harla, was prosecuted under a provision of this enactment for the possession of the opium in the excess amount as prescribed by the legislation itself. When Harla was prosecuted for the violation of Jaipur Opium Act, then this prosecution was challenged on the ground that this legislation, this law was never published, and therefore it cannot be enforced, it cannot be implemented. The Supreme Court of India established the fact, the Supreme Court of India held in this case that no law can be enforced until it is published. So, the Indian judiciary has established the fact that the post publication is mandatory and no delegated legislation, no legislation even can be enforced until it is published. The mode of publication is also an important issue in the process of publication of delegated legislation. As we can understand that the requirement of publication has been made to make the public capable of understanding the new rules, new law, and to make them capable for changing their conduct, for adopting their conduct in accordance with the requirement to be made by these new rules or new delegated legislation or the new law. This is the purpose of the publication, so that these rules should be known by all the concerned, all the interested groups, all the interested persons, and therefore the mode of publication becomes very relevant. Friends, suppose if the publication has been made very properly, it has been made in accordance with the requirement made in the Parent Act or in accordance with the requirement given in any general law, but the proper mode was not adopted in publishing the delegated legislation. For example, if the delegated legislation is made for the persons residing in the area which is very backward and the people residing there are mostly illiterate, the administrative authority chooses to publish the rules or delegated legislation in daily newspapers as it was provided in the Parent Act, but it publishes that delegated legislation in daily newspapers in the language of English, which the residents of that area do not know. What is the effect of this publication? What is the consequence of this publication? Whether the objective behind the publication is fulfilled? No. The objective behind the publication cannot be fulfilled if the publication is not made in the language which is known to the persons of that area, and therefore this publication is of no use. This is the reason for which the mode of publication also becomes important, also becomes significant, also becomes relevant for any delegated legislation to publish. The mode of publication may be mandatory, the mode of publication may be directory, in accordance with the phraseology, in accordance with the words, in accordance with the language being used by the legislature in the Parent Act in making the requirement of publication. If the mode is provided by the Parent Act and it is provided that in this particular mode the delegated legislation should be published, even then that requirement made in the Parent Act may be mandatory or directory depending on the language, depending on the phraseology adopted by the legislature in enacting this particular provision. We know the provisions may be of two kinds: the obligatory provisions, directory provisions, or mandatory provisions. Mandatory provisions are the provisions wherein the legal consequences of non-compliance of those provisions is provided or is prescribed. If the legal consequences of non-compliance of that provision are not provided or not prescribed or not specified by the legislature in the enactment itself, then this provision cannot be considered to be mandatory, even if the words like shall are used and the legal consequences for non-compliance are not provided. It has been the approach, it has been the opinion of the Supreme Court of India and various courts elsewhere also that such provisions cannot be considered to be mandatory. But if the word like may is used in association with the prescription of the legal consequence for non-compliance of that provision, the provision becomes mandatory. So the provisions may be of two kinds: the mandatory provisions for making the requirement of any particular mode for the publication of post-publication of delegated legislation, and the directory or obligatory provisions to make the requirement of any particular mode for publishing the delegated legislation. If the requirement is considered to be mandatory on the basis of its interpretation, then it becomes the mandatory obligation over the authority concerned to publish the rules or delegated legislation in the same mode, in the same manner as prescribed by the Parent Act. But if the requirement making the requiring particular mode of the publication is considered to be directory on the basis of the interpretation of the provision, then it is not mandatory for the authority to publish the rules or delegated legislation in the same manner, in the same mode as prescribed by the Parent Act. It may choose its own manner, its own mode to publish the rules or delegated legislation, but subject to one condition, that the mode as opted by the administrative authority for the publication of delegated legislation should be such which is an effective mode, which is the mode capable of giving the effective information to the public concerned, to the people concerned, to the interested groups, to the interested persons about the delegated legislation. You can refer to the case Raja Buland Sugar Company versus Rampur Municipality in this regard. Then the next kind of control, which is also associated or connected very closely with the procedural control, is the parliamentary control. We completed the discussion on the procedural control, including or all the 4 stages of delegated legislation: the drafting, the pre-publication, the process of consultation, and then the requirement of post-publication of delegated legislation. The legislative control or parliamentary control, it is very popular control in Britain, but the position in US is contrary, is in contrast with the position in Britain. We know that in US the parliamentary form of the government is there, and therefore the legislature is not allowed to interfere in the field of the executive. So the parliamentary control of delegated legislation is not so popular in US as it is popular in Britain, where the parliament is sovereign. The justifications behind the parliamentary control are: number 1, that every delegate should be under the control and supervision of the delegator. This power of delegated legislation, or the authority or power which has been delegated by the legislature itself, by the exercise of which the administrative authority or the executive branch of the government is making the delegated legislation. This is essentially the power of the legislature, and legislature delegates this power to the executive or administrative body, and therefore it is the duty of the delegate that it should work under the supervision of the delegator, supervision of the authority which delegated this power to the executive or administrative body. So the first justification behind the need of parliamentary control, the need of legislative control, is that every delegate should be under the control and supervision of the delegator. The second justification behind the parliamentary control is that delegator must have the authority to direct and correct and revoke the delegated power. As we earlier discussed, that the delegation does not mean denudation. Delegation does not mean giving up of the authority, giving up of the power to legislate. In earlier lecture on the constitutionality of delegated legislation, we have understood very well that the delegation does not mean giving up, delegation does not mean denudation, and therefore the delegator always retain this power in its hand to revoke or to withdraw the delegation at any time, number 1. And number 2, the delegator or the legislature always retains this power that it could legislate concurrently with the administrative body making the delegated legislation by the exercise of delegated power. So the parliament can legislate on the same subject for which it has delegated its legislative power to the executive. It means that the delegator, the legislature, does not denude, it does not give up its power by way of delegation. This is only the arrangement for the convenience of the legislature, so that the requirement of the law as to the quantity and quality can be fulfilled. So, the justifications for the parliamentary control or legislative control are that every delegate should be under the control and supervision of the delegator, and delegator must have the authority to direct and correct and revoke the delegated power. This is the reason for which the Supreme Court of India has very rightly observed in Avinder Singh versus State of Punjab, decided 1979 by the Supreme Court of India. In the case of Avinder Singh versus State of Punjab, the Supreme Court states that the parliamentary control on delegated legislation as a constitutional necessity should be a living continuity. So, the Supreme Court opined in the support of living continuity of parliamentary control over delegated legislation, legislative control over delegated legislation as the constitutional check or the constitutional control over the authority of executive in making the law. In the United States of America, the legislative control on delegated legislation is extremely restricted because of the presidential form of the government, because of the doctrine of separation of powers as the most basic, as the most fundamental constitutional principle. In United Kingdom or in Britain, the parliamentary control over delegated legislation is very comprehensive and effective because the parliament is sovereign there. In India, it is an usual requirement under the arrangement of, under the regime of the responsible government. We know that in the parliamentary form of the government, the executive is always responsible to the legislature. When the executive is responsible to the legislature, it means for each and every exercise of power, for each and every action, for each and every executive act, the executive is responsible to the legislature. The executive is to explain before the legislature each and every exercise of power and each and every action being taken by the executive. In this regime of responsible government, where the executive is responsible to the popular house, is responsible to the legislature, it is the duty of the executive to explain its every action or every exercise of power on the floor of the legislature. This is also the justification behind the requirement of the parliamentary control in the regime of parliamentary form of government. Parliament controls the delegated legislation in two ways. There may be the direct control over the delegated legislation by the parliament, by the legislature, and there may be the indirect control of the legislature over the delegated legislation. The direct control on the delegated legislation is made at two stages, at both the stages of delegated legislation, at the stage of pre-enactment of delegated legislation and at the stage of the post-enactment of the delegated legislation. At post-enactment stage and at pre-enactment stage, at both the stages, the legislature controls the delegated legislation directly. So, the direct control over delegated legislation can be divided into two: pre-enactment control and post-enactment control. The whole control mechanism by the parliament or whole mechanism of parliamentary control, the legislative control, may be classified, may be divided into two: the direct control and indirect control. This direct control may further be divided into two: at pre-enactment stage and number two at post-enactment control. Then the indirect control, which is made by some committees of parliament, is always done at the post-enactment control or after the delegated legislation has been made. Direct control by parliament as it is divided into two. So, first we will talk about the direct parliamentary control at pre-enactment stage. The direct parliamentary control at pre-enactment stage is made through various initiatives being taken by parliamentarians or the members of parliament when any such bill is introduced on the floor of the house which has any provision for making the delegation of legislative power to the executive. So, if any delegating statute means the statute, the legislation which is going to delegate legislative powers to the executive. So, whenever any delegating statute, any bill, delegating bill or any bill intended to delegate the legislative powers to the executive is introduced in the parliament on the floor of the house, there may be the debates on that bill which contains the delegation. The debate can be conducted by the members of parliament on different aspects of delegation. The debate may be there among the members of parliament regarding the limits of delegated legislation, regarding the extent of the powers being delegated, regarding the nature of legislative power being delegated, whether it should be delegated or not, and if it is to be delegated, then to what extent and with what restrictions or what conditions it should be delegated. On all these various aspects of delegation of power, there may be the debate in parliament among the members regarding the delegating statute, regarding any bill containing the provision of delegation of legislative powers. There may be the questions and notices by the members of parliament. The members of parliament can raise the questions regarding these different aspects of the delegation of legislative power. The notices may be served regarding the delegation of powers. The members can pass the resolutions in the parliament in favor or in opposite to the delegation, to the proposed delegation. Vote of grants may be there, and the private members can introduce the bills. So, the private member bills, through the private members bills, this control can be made at pre-enactment stage. Parliament controls delegated legislation directly at this stage by all these means which we discussed. But friends, it is also the fact that at this stage, when the debates are made, when the questions are raised, when the resolutions are passed, when private members' bill are introduced in the parliament, what happens? What are the consequences of all these efforts of the members of opposition? We know the legislative process. Any bill can be passed by the simple majority of both the houses. If the simple majority of Rajya Sabha, simple majority of Lok Sabha, simple majority of House of the People, simple majority of Council of States is in favor of the bill, then all these efforts, all these activities, all this discussion, all these debates, all these questions, all these notices, all those resolutions, these are worthless, these are useless. The government can very easily pass the bill, and no amendment may be made by the government even if these amendments or changes are sought by the opposition or sought by the members of parliament. It seems that this direct control at the pre-enactment stage of delegated legislation, it not very effective control, is not very strong control. It depends on the number game, and if the government has the majority in both the houses, it can pass the bills containing the delegation of legislative powers with very easily without giving due considerations to all these issues or all these apprehensions or all these objections which have been raised by the members of the House, the members of Parliament during the debates and discussions. We can say that the parliamentary control, direct parliamentary control at this stage seems not to be very sound, very effective control, and therefore now we are to see that what is the status of the post enactment direct control by Parliament. Parliament also controls the delegated legislation directly at the post enactment stage, at the stage when the delegated legislation has been made finalized. Through the process of laying, this control is made. The process of laying may be of different kinds. There are three important kinds of laying: laying subject to affirmative resolution, laying subject to negative resolution, and laying subject to no resolution or laying subject to no action on the part of Parliament. Simple laying. There may be three kinds of provisions making the requirement of laying. One, that the delegated legislation shall be laid on the floor of the House as soon as it is made. This is very simple provision making the requirement of laying. No consequences for non-laying, no consequences for the non-compliance of the requirement of laying is provided, is mentioned in the provision. No resolution on the part of Parliament regarding the effectivity of delegated legislation is mentioned in the provision, meaning thereby that it is the simple laying where the Parliament is to do nothing with the delegated legislation. In this simple laying, when the Parliament is not to pass any kind of affirmative or negative resolution, as the delegated legislation is laid on the table of the House, it becomes enforceable, it becomes effective. So, the effectivity of delegated legislation depends only on the mere formality of laying this or putting this delegated legislation on the table of the House. The Parliament is to do nothing. As it is laid on the table of the House, it becomes effective. So, this simple laying is the mere formality, and therefore it cannot be the mandatory requirement. Even if the delegated legislation is not laid on the table of the House, it may become effective. It does not render the delegated legislation as invalid. The second kind of laying is the laying subject to affirmative resolution. In this kind of laying, the delegated legislation becomes effective as it is laid on the table of the House, but the delegated legislation becomes effective only when the affirmative resolution is passed by the Parliament in the favor of effectivity or enforcement of delegated legislation. So, the delegated legislation becomes effective only when the Parliament passes the affirmative or positive resolution in its favor. That means that the delegated legislation cannot become effective, cannot become enforceable until and unless Parliament passes any such affirmative resolution. This means that this requirement of laying is mandatory. Laying subject to negative resolution, the delegated legislation becomes effective as it is laid on the table of the House, but it ceases to have any further effect as any negative resolution is passed by Parliament. But we know the Parliament does not have sufficient time to make the scrutiny of each and every piece of delegated legislation. If the Parliament would have such a time to scrutinize each and every piece of delegated legislation, then there would have been no requirement of delegated legislation. The process or technique of delegated legislation was discovered for the reason that the Parliament had the lack of time. There was no sufficient time with the Parliament to deal with all these enormous subjects and to produce such quality and quantity of law which was required during the complex form of government under the regime of welfare state. So, this is also not possible for Parliament to scrutinize each and every piece of delegated legislation. In this light, it seems that the laying subject to negative resolution where the delegated legislation becomes effective as it is laid on the table of the House and it ceases to have any further effect only if the Parliament passes negative resolution, it is also not mandatory. Once it is effected or it is effectuated, it is effectuated for all the time because Parliament does not have sufficient time to scrutinize. So, this process of laying or the control of delegated legislation through the process of laying at the post enactment stage of delegated legislation, it also seems not to be very effective control on delegated legislation because of one more fact also. Whether the requirement of laying is mandatory or not, it also depends on the nature of the provision in the parent act making the requirement of laying. Whether that particular provision is mandatory or not, it depends on the phraseology adopted by the legislature in enacting the provision. So, if any legal consequences have been provided in the provision itself by the legislature in the parent act, only then the laying becomes mandatory. But if the simple provision making the requirement of laying is made without providing for the requirement of the affirmative resolution on the part of the Parliament, if no consequences are provided, then such laying cannot be the mandatory requirement, and therefore, this direct control of Parliament at pre-enactment stage and at post-enactment stage both seems to be not very sound and strong control by the legislature. Now, see the indirect legislative control or indirect parliamentary control. This indirect legislative control or indirect parliamentary control, indirect legislative control or indirect parliamentary control is made by the Parliament, by the legislature, by or through the committees of Parliament. In India, in 1953, the Lok Sabha Committee on Subordinate Legislation was constituted, and in 1961, the Rajya Sabha Committee on Subordinate Legislation was constituted. The Lok Sabha Committee on Subordinate Legislation is 15 members committee. It is 15 membered committee and the members of this committee are nominated by the Speaker of Lok Sabha. It is the usual practice that the chairman of the committee is appointed amongst the members from opposition. The opposition member is appointed as the chairman of the committee, 15 membered committee. The committee has the term of 1 year. In Lok Sabha Committee on Subordinate Legislation, the ministers are not allowed to be the members of the committee. They cannot be the members. The Lok Sabha members who are also the ministers or who are occupying the portfolio in the Council of Ministers, they are ineligible to be the member of Lok Sabha Committee on Subordinate Legislation. The party considerations are not allowed to be discussed during the deliberations by the committee on the virus of the delegated legislation. This is the Lok Sabha Committee on Subordinate Legislation. Rajya Sabha Committee on Subordinate Legislation is also 15 membered committee. But the term of Rajya Sabha Committee, it is of some permanent nature. The committee continues till the next committee is constituted. The members are nominated by the chairman of Rajya Sabha, Council of States. In Rajya Sabha Committee for Subordinate Legislation, Rajya Sabha Committee on Subordinate Legislation, the ministers can also be the members of this committee. The term of committee is not specified. If we see the functions of the committee, committee is to scrutinize the delegated legislation with respect to various aspects. For example, that if any retrospective effect is given to the delegated legislation, if the power of judicial review has been taken away by the delegated legislation, if the delegate or the administrative authority making the delegated legislation travels beyond the power which was conferred on it by the Parliament, whether there was any undue delay in making the delegated legislation, whether the proper mode of publication was adopted by the administrative authority making the delegated legislation, whether the publication was made in effective manner, whether the process of consultation was adopted during the making of delegated legislation or not, whether there was any undue delay in the publication of delegated legislation. These are some important functions which are assigned to these two committees on subordinate legislation. Then what are the powers of the committees? Committees are only recommendatory bodies. These committees do not have any such power. They can make the recommendations only to the House, and it depends on the House to take the action in accordance with the recommendations of the committee. The main function of the committee to scrutinize the pieces of delegated legislation and to find out about different issues which I told you. In scrutinizing various pieces of delegated legislation in the course of time, both the committees have made some recommendations for the administrative authorities, which the administrative authorities are to take care of during the process of delegated legislation. These suggestions or recommendations of the committee are: number one, the power of judicial review should not be taken away by the rules, by the delegated legislation. The financial levy or tax should not be imposed by the delegated legislation. The language of the delegated legislation should be simple and clear. The rules should not be given retrospective effect. The legislative policy should not be laid down by the administrative authority or by the delegated legislation. The sub-delegation should not be made unless it is sanctioned, it is permitted, it is approved by the parent act. Discriminatory rules or discriminatory delegated legislation should not be made by the administrative bodies. Rules should not travel beyond the power which has been conferred by the legislature in the parent act. There should not be any undue delay in the publication of delegated legislation. The delegated legislation should not be enforced without making it public or without making the publication of it. Final authority for interpretation of rules should not be with the administration. Final authority for the interpretation of the rules should not be with the administration means that the authority of judicial review should continue. It should not be taken away by the administrative body in making the delegated legislation. So these are the recommendations, or these are various suggestions made by both the committees on subordinate legislation in India with regard to the effectivity of, with regard to the popularity of, with regard to the fulfillment of the objectives of the delegated legislation, fulfill the need of the delegated legislation. Thank you very much.